the fourth recommendation, and it relates to a hearing officer's authority under Rule 13. So, Kamal, could you just explain briefly sort of what that recommendation is about?
So Rule 13 itself um, essentially is the subsection of the Michigan Admin Code that governs these types of license restoration hearings. The issue tends to be that the language used in Rule 13 is pretty broad in scope, and so it allows the hearing officer to consider a number of issues, which in some cases may or may not necessarily be indicative of whether that person is a threat. One common theme that we would hear at these clinics is the hearing officer wanted me to show them that I was still doing AA, right? Even though the offense may have been 20 years ago, the person may have initially done some type of AA or some type of structured court ordered rehabilitation program. But then there's an ongoing expectation that that person continue to do that. And I think the frustration there is that just because I am no longer in that type of program doesn't necessarily mean that that my substance abuse problem is not under control.
There needs to be a recognition that if they have presented evidence that they have done other things to heal from the incident or what their circumstances were, and they have a licensed substance use evaluator provides an evaluation, if they're saying that this person is in recovery or in remission, and they have evidence that they are abstinent from using alcohol or controlled substances, then that should meet that burden of clear and convincing evidence.